Good afternoon, everyone, and welcome to our webinar today. Thank you for joining us. We're hoping to have a sort of practical and insightful session on voluntary liquidation. We are joined today by two of our experts in the field, who bring a wealth of experience and real life knowledge to the topic. Gary Scott and Ronan Duffy. We'll also have a Q&A at the end, so if you want to pop any questions into the chat, we'll do that, as I say, at the end of the session. Without further ado, over to you, Gary and Ronan.
Okay, thank you very much, everybody. Thanks very much, Damien, for that introduction. I was kind of wondering at that introduction when you were talking us up, I was wondering who else was joining. For those of you who don't know, my name is Ronan Duffy. I am an insolvency practitioner with McCambridge Duffy. I'm a chartered accountant for my sins. But I also, as well as being a chartered accountant, I act as an insolvency practitioner and a PIP in Ireland. I'm also a UK qualified insolvency practitioner, so I have experiences of cases in Northern Ireland and actually indeed across England and Wales. Today's seminar, I appreciate that you all join us. It's outside, it looks not bad, so perhaps you could have gone to the park with your sandwich, and I'm glad that you've decided to take the time to join us today to try and understand a little bit more about voluntary liquidations and the process involved and the implications for directors. So Gary, do you want to sort of move the next slide on? Our presentation, today, I should have pointed out, is incredibly timely. We had prepared these slides previously. Gary and myself had worked on them, and then obviously the best laid plans of mice and men. On Friday afternoon, the Corporate Enforcement Authority issued its annual report for 2024. So I kind of had suspected it was going to be sort of end of June, start of July, but the fact that they updated their stats and so forth on Friday made for a hectic morning this morning, reviewing the slides to make sure we were up to date. Today I'm just going to touch a bit on I've said voluntary liquidation. Really, in Ireland, just so you know, there are three types of liquidation. There's two of those are voluntary, and one of those is compulsory or official liquidation, and that's the court-driven liquidation in the High Court. We're also going to touch on the investigations, and basically what comes out of it is that a CVL, or a Creditors Voluntary Liquidation, is that the liquidator is obliged to report to the Corporate Enforcement Authority. The liquidations as a whole have a range of potential implications and potential impacts upon directors. So we're going to touch on those a little bit. And we're also then going to sort of wrap up with some looking at some case studies that are sort of try and pull it all together and demonstrate what we're actually sort of talking about in terms of the reporting. Okay, so just as I say, go on to the next slide then. I had mentioned there the Corporate Enforcement Authority. Now, the Corporate Enforcement Authority, for those of you who don't know, perhaps, were established in 2022. It replaced the Office of the Director of Corporate Enforcement, which came into place almost 25 years ago. It was 2001, and basically both those authorities have had responsibility for trying to draw together and drive forward the the framework for effectively corporate enforcement. Prior to that, it had been there had been widespread breaches of company legislation, and it was sort of seen as being a bit of a kind of a wild west in Ireland compared to other jurisdictions. So when I said then that I mentioned the Corporate Enforcement Authority, there's a number of key differences between the liquidations. As I say, there's the three types of liquidations. There's the Members Voluntary Liquidation, the Creditors Voluntary Liquidation, and the compulsory or official liquidation. The two of those, as I say, are voluntary, the MVL and the CVL. Two of them are solvent. The CVL, are insolvent rather. The CVL and the compulsory liquidation. So the MVL is a solvent liquidation, and it's a key difference. But in all of this, I'm going to run through the differences between those two types of voluntary liquidations, just to get them right in everybody's head. But the key difference in all of it is that one of the key differences rather is that there's no director disqualification or no director restriction reporting in an MVL, whereas the CVL would have it. Okay, so if the company is solvent, as in its assets exceed its liabilities, and it's able to, it may be that it's come to the end of its economic life, and that the shareholders effectively want to take their money out. They do have a declaration of solvency, which obviously isn't possible in a CVL, which is an insolvent liquidation, and insolvent so far as the liabilities exceed the assets, and it's not able to pay its liabilities as they fall due. So in an MVL, the directors make a declaration of solvency. And whilst the liquidator is appointed, the shareholders, in effect, are still sort of in control. And it's a tax-efficient way for... Oh, sorry. Thank you very much. Thank you. Sorry, somebody just brought me a coffee. Very nice. It's a very efficient way for, from a CGT point of view, for a company to be wound up. Because in an MVL, creditors are paid in full, along with the associated costs. There's no real creditor involvement. In a CVL, obviously, there's a lot more creditor involvement, and creditors are kept informed throughout the process. Right, Gary, do you want to move on? So, as I said, three types of liquidation. One is solvent, two are insolvent. Of the two that are insolvent, when a liquidator is appointed, be it an official liquidator by the High Court, or effectively examiners, sorry, they have similar obligations, similar duties. As a liquidator, when you're appointed in a CVL, what you look to do is you look to get the assets in, realize those assets for the benefit of the creditors, but you also look to early doors. You look to secure and uplift the books and records. Nowadays they may be on the cloud or in electronic format rather than physical ledgers. But irrespective, everything that constitutes books and records of the company, you look to get in. And you do that for a number of reasons. One, that drives forward determining the assets and whether or not there are any assets that can be realized for the benefit of the creditors. But the second reason you do it is actually to carry out your investigation as a liquidator. If you carry out your investigation as a liquidator, you will determine the reasons and rationale for the failure of the company, effectively why it it couldn't avoid liquidation and why it ended up in liquidation. And you also do a report then to the Corporate Enforcement Authority on the conduct of the directors. So liquidators investigations are, you obviously it's driven by the Companies Act 2014, but it's also driven by the Statement of Insolvency Practice 2B. It's similar to, as I say, to other jurisdictions in so far as SIP2 in the UK is broadly similar to SIP2B. There are obviously some legislative differences, but in terms of trying to determine the reasons for the failure and determine whether or not the conduct of the director was appropriate, those investigations have to proceed as quickly as you can. So in the liquidation, the liquidator has the primary duty to try and realize the assets for the benefit of the creditors. But I think it's equally important to try and determine whether or not the director's conduct is appropriate, as I say. And in all of it, what you're trying to do is determine and pull together evidence as to whether or not the directors have acted honestly and responsibly. And that is that flips on its head a little bit if you were to compare what happens in other jurisdictions. In other jurisdictions, I've been involved in liquidations in North America and in Europe as well as the UK. But in those liquidations, the director is I shall say this politely, is innocent until proven guilty. So that as a liquidator, you assume that the director has acted appropriately until you find evidence to the contrary. In Ireland, we've managed to flip this on the head, and the really in all such liquidations, the liquidator is almost guilty until proven innocent. So you're looking to determine and find out evidence of have the directors acted honestly and responsibly, and so you have Gary. I'll try to come on to it a bit more. You've got 6 months to do your initial report, but thereafter, if something comes to light, obviously you would do a subsequent report to the Corporate Enforcement Authority. I think that's. I think you're hand over to Gary at this point for the time being. So Gary, you want next slide and rock on?
Yeah, no, thanks, Ronan. Yeah, so look, as Ronan said there, your primary duty as a liquidator is to realise funds for creditors, and an investigation plays such a crucial role in that. Your investigation should always be proportionate and appropriate, and you'll look at that and review that on a case-by-case basis. But so it'll also allow you to report clearly to creditors on the steps that you've taken. So as Ronan had mentioned, there is a statutory requirement on all appointed liquidators to submit a report to the Corporate Enforcement Authority within 6 months of appointment on directors' conduct. And really what you're looking to do is form an opinion as to whether or not the directors have acted honestly and responsibly. The report hasn't changed too much over the years, or recent years. That there has been some recent changes in 2023, which included you should now also include a statement of revenues, collections, and payments, which can, in theory, be quite difficult to get. But also you have to have regard for employees, and really it's not that's more a duty to the company as opposed to the specific employees. So around insolvency planning, timely communications with employees. So there are a number of potential outcomes from that report. The directors or the liquidator can seek relief, which basically means that you form the view that the directors have acted honestly and responsibly. Or if there has been areas identified, you would basically be considered restriction or disqualification. So I'm going to chat in a bit more detail about the differences between the two. Restriction typically lasts 5 years. And it applies with directors of an insolvent company, and where you've proven that they've acted, you can prove that they haven't acted honestly and responsibly. And then disqualification generally is for a longer period of time, and it's sort of used for more severe misconduct. And we can actually go into a bit more detail on that when we look at the case studies. So there's a number of enforcement mechanisms for this. The directors can either be restricted or disqualified by High Court order, or over recent years with the introduction of the voluntary undertakings. What we will see shortly is that there has been a significant uptake in those, which has kept it really out of the court system. So as Ronan mentioned, we've had this slide prepared, but obviously with the new Corporate Enforcement Authority's report that was submitted, we've provided the figures for 2024 as well. So as you'll see there have been 680 liquidators report filed in 2024. And there have been 22 directors disqualified and 98 directors restricted. From those 70% of the directors disqualified had been done by undertaking, and the restrictions had been 90%. So what this shows is that there has been an uptake to try and to keep it out of the court system. What you'll find as well is it's not as widely publicized. Whereas obviously if it's a full court order, you'll obviously be in the court system. So the triggers for restriction that the directors have failed to act honestly and responsibly. It's a standard 5-year duration. And the implications of that is that the directors you cannot act as a director unless you meet certain share capital requirements, and that is 100,000 for private companies and 500,000 for PLCs. For both direct restriction and disqualification, it applies to directors, shadow directors, and de facto directors who have held office within 12 months of the winding up. As I mentioned, there is the voluntary option where you can accept the undertakings which sort of avoids court proceedings, which also have cost implications. For restrictions, subsequences of breach, it's an automatic disqualification, and for disqualification, it is a criminal offence to act as a director whilst disqualified, and it is maintained on the CRO public register.
Sorry, Gary, could I just say one thing? Just one of the things that struck me about the recent figures, there was 980 liquidator reports were received by the Corporate Enforcement Authority, and then that resulted in 98 directors being restricted. Now, initially I was thinking, so it was like 10% of cases where directors hadn't acted honestly and responsible, but the actual fact, those reports,
there's time issue.
There is subsequent reports as well as so that what I was saying earlier, as a liquidator, you have to do your report and you work to get that done as quickly as you can, and then as your investigations progress, or perhaps your your recovery actions progress, something else comes to light, and you do a subsequent report. So I think a lot of of that 980, I think I don't know, it's like 20 to 30% of those are subsequent reports, not first reports. And the other thing is that, as you said, Gary, is the timing. Yeah. And I think when we've been discussing it before, you were saying about how long that it can be. Those liquidator reports obviously relate to liquidations within the period, late 2023 and 2024. The period under review. But as you were pointing out to me previously, sometimes the enforcement action can come years later.
Yeah, well, there's one of the case studies within the recent CA report that was put up on Friday, where the liquidation had been 2014, and it was only before the final decision of the court was early last year. We have a case, internally as well, where it had gone on for nearly 10 years as well. So, I wouldn't be sort of looking at it 980, no, as a comparison of that 980 that 22 directors have been disqualified, because there is no obviously going to be timing issues, because these matters do sort of be ongoing for a number of years.
Yeah, one thing worth pointing out as well, I think, is that the overall the stats for the corporate insolvencies were sort of artificially depressed during, as a result of the pandemic in 2020, 21, 2022, and the revenue obviously had the debt warehousing, which finished last year. So it's actually, there is an uptick in the CVL figures. CVLs are the most common insolvency in Ireland, and although we would expect to see more reports come through over the next couple of years, with consequently more restrictions and more disqualifications. Could I just at this point, I know, sorry, Gary, I know this was your slide, but I still remember one of the liquidation that I'd done, and it was kind of textbook director conduct, everything that you could expect them to do. I thought that it was clear that they had done everything, and they were two thoroughly decent individuals, and they had acted honestly and responsibly. And we had sort of submitted a report which was going over page after page of bullet points of that their conduct had been honest and responsible. And obviously we were looking for relief from having to take restriction proceedings. And I do remember this was the early days of the Corporate Enforcement Authority only formed in 2021. Sorry, 2022, July 2022 it was. And but they came back and sort of said, is there nothing else? And I've done all this work with these guys, and we pretty much went back and said, listen, the guys still have their communion money, if that helps. It was, we did do a bit more than that, but it was like, it was, but although we felt we had done a good report, it was questioned. And I think that is sort of something that is noticeable as well, is that that when you look at the CA's report, is that the liquidators' reports haven't been adequate, or they haven't been in receipt of them. Now, this kind of blows my mind, is that a liquidator would be appointed, they know their obligations, they know their statutory requirements, and yet they neglect to submit a report on and actually it necessitates the CEA going to court to compel them to it. It just blows my mind on that one. So sorry, Gary.
No, you're fine.
Oh,
over to yourself, Ron.
What do you mean? Sorry, I took your slide. Do you want to talk about some of my stuff? No, sorry.
No, go ahead.
Right. With regards to obviously when a director, they're a human being, and they it is quite traumatic. No one really, well, to the best of my knowledge, the vast majority and I'm talking the vast majority, no one ever sets out to establish a company for it to end up going into liquidation. Okay, it tends to be something that triggers. Maybe it's a squeeze on margins. Maybe it's bigger competitors in the market. Maybe it's it could be any number of things that result in the company ultimately not being successful, and that failure has implications for the creditors. It has implications for the staff. staff will by and large get looked after by the department, but it also has impacts on directors, personally. And I just wanted to sort of take a little bit of time to look at those. There can, when a company goes into liquidation, there can be personal guarantees. Sometimes I did a case there recently where they had they probably traded on 18 months, 2 years beyond where they should have. But during that time, they'd taken on board an additional 10 creditors who were all PG'd by the director. And that equated to about 600,000 of liability that the director had taken on themselves. Now, I don't know if it was ego or pride or whatever that he felt, or just this belief that he could turn it around, and that he'd taken on what I viewed as inappropriate, lending to the company, inappropriate insofar as he PG'd it all. So so PGs are something that you have to have regard to. As a director, but also as a liquidator, you have to be alive to them, because you would review when I say you uplift the books and records and your investigations proceed. You would review, is there anything peculiar about the payment history? And we have encountered cases where there's been effectively an unsecured creditor, the same as everyone else. And everyone else has been getting minimal payments, and they've been getting substantial payments. And then when you dig out a bit further, it transpires that there was a PG in place in respect of those liabilities. And if there is a PG in those places, and the director has made payments, significant payments to it, it's a bit of a penalty kick that's an unfair prejudice, and can be. As a liquidator, you can seek to recover it from the director. Directors' current accounts, obviously, directors, tend to draw out their, a mixture. I'm talking cases where they are effectively owner shareholders, so they have they're acting as a director, but they may take some of their remuneration in the form of dividends. So if you're actually, as a liquidator, one of the things that you'd look to do is try and get the details of the director's loan account and look to reconcile it. Now, it may be that in effect that they've been drawing excessive drawings, that they've, that historically they had been taking, this level of remuneration, be it part in salary and part in dividends, and then that looks to, as it comes towards the end of the life of the company, they look to ramp up that, because they're panicking, they're worried that they're about their own livelihood and so forth, so they're trying to draw monies out of it. So if a company, if it ends up that the director's loan account is overdrawing, and in effect they are that overdrawn director's loan account is an asset of the company, and the liquidator is then obliged to pursue it with the treat it effectively like any other debtor and look to recover it. Now, quite often, as a liquidator, you can work with somebody. You can say, listen, the director's loan account is overdrawn. We would need to determine how you're going to repay it, and you could work with them that it's repaid over a period of time, and obviously you report that to creditors in your reports. However, if you actually look at the director's loan account and maybe they've applied dividends during the period, you would take a step back and you'd say, look, were there distributable reserves within the company? Was the company in a position to declare those dividends, or were they effectively illegal dividends? And if that's the case, then you reverse it out of the director's loan account. The director's loan account is actually therefore higher than had been reported by the director, and you look to pursue that higher amount from the director. So one of the other things then is sort of the antecedent sort of transactions, and that's have they that what I've mentioned about preferences, have they, it may be that that they preferred a creditor because there's a PG, but it may be that perhaps that they preferred a creditor for some other reason. So again, you would review the payments to creditors, and you would when I say that, it may be an unfair prejudice, perhaps their wife or sorry, their spouse or whatever, or a family member had lent them some money to try and prop up the company, and then and then in desperation, as everything goes awry, they try and repay that, because they but that in effect could be as an antecedent transaction, could be a preference that you need to sort of pursue as well. So also, one thing sort of worth mentioning is, that overall on director's loan account, there can be sort of tax implications that, treated effectively like income tax in effect if it's an event of the sort of loan forgiveness. In all of these, though, where there's PGs, where the use or misuse of a director's loan account, and those antecedent transactions, you would look to sort of include them as a liquidator within your report to the Corporate Enforcement Authority. Gary, do you want to scroll to the next slide? Right. So this is kind of where I'm just trying to sort of pull it all together, and it's a bit complicated perhaps, but if you think about that, as I said, that director is a human being. They're sort of they're they have faults like the rest of us. They have good attributes like the rest of us, and it's but they're going through a bad situation. They're going and sometimes their actions may have been influenced by the uncertainty ahead. And, but for many, a director going through a liquidation, it will have a reputational impact. People feel embarrassed about it. People feel, maybe not so in America, where it seems to be a sort of just go bust and start up the next day. And it's, that sort of sulk in the valley, you're not a success unless you've been sort of gone through sort of 2 or 3 liquidations. But so can it impact their reputation? Certainly can impact their, we see cases where it's that's their livelihood, and that's what they've been relying on for the past number of years, and they can't see the wood for the trees. They can't see any alternatives, and so they're kind of looking at this so it's that difficulty of sort of trying to encourage them on to sort of get a new job, or go for something else. And we have encountered many cases down through the years where they've been a sort of this kind of reluctance to let go, reluctance to try and move on, and then 12 months later they come back and say, best thing that ever happened, should have done a long time ago. Had that cloud hanging over me for all that long. It's given me a new lease of life and so forth. So it's not always the light at the end of the tunnel is not always an oncoming train. So we touched upon then sort of previously sort of the personal guarantees. Now, what happens then if there is a personal guarantee? As I said, the liquidators is typically not involved in a PG unless there's been sort of some sort of that they've unfairly prejudiced because of the PG. But say, for instance, it's a PG, and the creditor is going to sort of come knocking, and effectively they'll be looking for it that it'll either be repaid. They look for some sort of settlement or repayment plan, but it could actually also result in personal insolvency. So that that case where I'd mentioned that they had hung on too long, that they had incurred 600,000 of additional borrowings that had almost PG'd. That's a nailed on personal insolvency, and so that is so it's the domino effect, if you like. The company got into difficulty, company went insolvent, created difficulties for the director, which resulted in personal insolvency. So similarly, from the personal guarantees, the director's current account, as I said, when the liquidator reviews it, the liquidator goes through it, tries to reconcile all the transactions, the application, looks at the dividends in the previous number of years, looks at any movement, or you took out money there, or you put money back in there, or try to understand, what has happened. But it may result in then that there's a quantum that there at a particular point that the liquidator said, listen, the director's loan account is €120,000. What's your plan? We have an obligation as a liquidator to recover it. So either it's repaid, or some sort of settlement is made, or a repayment plan is come up with, or we have cases as well where as I say, it results in the personal insolvency of a director. And that's it's just kind of the nature of it. The liquidator rather has an obligation to pursue that asset for the benefit of creditors. The liquidator's investigations, will continue irrespective of the fact that the director's livelihood's gone, irrespective of the perceived reputational damage. But it could actually get worse for them, as Gary was alluding to, on if you end up in a disqualification situation, that it'll have a worse implication for the director's reputation than than if it was just that they were obviously obtained relief in that case. The liquidator's investigations, however, will they will the liquidator will look at, was the types of transactions, was there any fraudulent dispositions, did they sell any assets to and if they sold them, were they sold at an appropriate valuation, were they sold, did the company achieve value for creditors, and then what were those funds, how they were actually used for. They look at the statutory filings in the past number of years at CRO. As I say, they look at whether or not there's any unfair prejudices. One thing that is actually quite informative in a lot of these cases is the level of directors' cooperation or otherwise. I do remember a case years ago that there was, the director, his conduct had been fine. There was no issue. Everything pointed to the fact that they acted honestly and responsibly, but they just went radio silent. And then we ended up having to report to the Corporate Enforcement Authority that the director wasn't cooperating. And it was just some basic stuff. It was basic questions that required answer, but the director just, whether or not they buried their head or just thought that's all behind me, I don't need to think about it anymore. But for a director who had previously impeccable conduct, the fact that they kind of shot themselves in the foot then by not continuing to cooperate. When a liquidator is appointed, the director's powers cease, but the obligations on the director remain. And it's important to keep that in mind. But the fact that this director didn't cooperate, and we were imploring, saying, listen, you've done, it's all grand, just answer the damn questions, excuse my language. So one other thing that they will look at is whether or not it's the adequacy of the accounting records, and it's whether or not those accounting records are appropriate for the scale and nature of the operations. If the company is big, then you're going to expect that they're going to have an appropriate recognized software being used for the maintenance of the books and records. If it's sort of small scale, maybe Excel is appropriate. I don't think so, but they would look at the adequacy of the accounting records. I remember I had a case years ago where the father of the director determined that that this investigation was going to take place into their child, and having books and records wouldn't help the situation. So they took out all the books and records of the company and set fire to them in a field. Again, from that liquidator's perspective, that's frustrating. It's annoying. So you have to then piece together everything by going back through, bank statements and trying to, and previous filed returns and the books and records that didn't get torched. But it doesn't look clever from a report to the CEA that the books and records got torched. So it's directors need to be be very careful. And quite often, then, just with the red, amber, green that we've put in place over there, and this is the last of my mind map on that, is that the director ends up that they acted honestly and responsibly, and there's sufficient evidence of that the liquidator is granted relief from taking any restriction proceedings, failing which you may end up being obliged to take restriction proceedings. And as Gary said, that'll end up in a 5-year restriction, or up to 15 years on the disqualification side. And I think that's that this is obviously a significant impact for if somebody is looking to reinvent themselves and continue in a career in business, and the company went into liquidation. Lots of companies do with that it's that the directors acted honestly and responsibly, in which case they get to set up the next day and continue, rather than the restrictions that would be placed upon them, and notably the share capital. I think I'm on to you in the next slide, Gary, is that right?
Yeah, no, thanks, Ronan. So leading on from that, we've had a look and picked out a couple of recent disqualification restrictions. Feeds into what Ronan was saying there around the various directors' conduct, and the more severe elements of it that can lead to quite lengthy disqualifications. So the first case study, it's one a lot of you may have actually seen in the last few weeks, because it did receive a lot of publicity, and it was for Kieran Colin Butler. These are two of the guys behind the franchises for Starbucks, TJ Fridays, and the Cafe Rock, or Hard Rock cafes in Ireland. And they were restricted from acting in High Court proceedings. They were restricted from acting as company directors for 5 years. So it all related to the part of it to do with COVID subsidies, and there was a related company, Atherson, that was allowed to operate rent-free, which leading to Downhill's insolvency and liquidation in 2022. Now, quite interestingly, in this one, the judge found that whilst the directors had acted honestly, he determined they had acted irresponsibly, which it's a first time in my mind, Ronan, that I've actually seen that kind of judgment. So I think that it'll be interesting to see, if there are similar cases like this moving forward. But ultimately, it was around failing to ensure there was an enforceable mechanism in place which the company could obtain funds necessary to discharge its liability. So it's around this element of intercompany trading. Second one is in relation to Joseph Sheehan, who received 10-year director's disqualification. Now, he had been one of the co-founders of the Blackrock Clinic, and he issued here around the company had received just over €3 million from the sale of shares in a company called Marpole Limited, which was the operator of the Galway clinic. But most have been transferred out within a matter of weeks, leading to insolvency. So Mr. Sheehan, he was disqualified from acting as a company director for 10 years, and his wife was also disqualified from acting as a director for 7.5 years. And it was around, basically, the company funds had been diverted in around early 2020, the sum of around 2.6 million. At the time, the company was insolvent, and the liquidator wasn't able to trace them due to inadequacies in the books and records. And the High Court had found his actions to constitute a fraud in the company and its creditors. And then one of the most the longest bans actually received related to missing trader VAT fraud. Kevin Rabbit, who was a director of Westman Plant and Civils Limited, and he was banned. That actually should be 14 years and 3 months, which was one of the longest bans ever imposed. And he had admitted participating in a €1.2 million VAT fraud involving the misuse of a company's VAT number to import machinery from the UK without paying the VAT in Ireland. As part of this, he'd actually admitted not only to the fraud and creditors, and it was resulted in him becoming personally liable for over 1.5 million of the company's debts. And the judge described the fraud as carefully planned and coordinated. So there's a bit of a range there from cases of actually showing the matters which can ultimately result in restriction, and the more severe matters which can result in lengthy disqualification orders.
I think you're pretty sure it's Rabbit rather than Rabbit. I think you're giving him sorry.
Right. Okay.
You've been super posh there, Gary. Does anyone have any questions that they would like to ask, or Damien have any questions come through on the sorry, are you still there, Damien? You haven't fallen asleep?
Yeah, still here. We had just one question that is there a difference between the director disqualifications process and implications between UK and Ireland?
It's actually there's a couple of key differences now. What I think there is a big implication from the outset is that now we have experience in Northern Ireland as well as the Republic, but we also have experience in England and Wales, and it's worth comparing and contrasting the three areas. There's the average length of disqualification in the UK is 6.8 years. So that's actually, it's not gone on for 7 years. It's actually closer, or it's quite a lot more than the vast majority in Ireland are restrictions, which are 5 years. So, but they do have the same where they threaten to take disqualification proceedings, and then they'll take an undertaking in the same way. So that avoids costs for the director. It avoids the need to go to court, etc. Publicity in the two jurisdictions is similar. I think, though, as I said, it's 6.8 years compared to 5 years. I think the similar types of investigation, a SIP 2 investigation is very similar to a SIP 2B investigation, and they go through the liquidator will have to go through the same process. In Northern Ireland, they have 3 months to do the disqualification reporting, the initial disqualification reporting, rather than 6 months in Ireland. But in Northern Ireland, they are restricted. They have to take action within 3 years from the liquidation. As Gary was mentioning there, some of those cases can be dragging on for. Did you say one of them was 10 years old on the liquidations, Gary?
Yeah, actually more than 10 years. Yeah.
So if you're a director of a company, you've sort of set up a new company, you end up continuing, or perhaps you're successful, and then out of the woodwork, this sort of hangover from 10 years ago comes back to bite you. That's obviously this can have significant sort of long reach implications. In the UK, if you're acting as a director of a company and everything's going fine, then sorry, sorry, my son tried to phone me there. If you're a director of a company and everything's going fine, and then they look to disqualify you, you can apply to court for leave to continue to act as a director of that company. But in both jurisdictions, you are kind of looking at, a disqualification of like 10 to 15 years tends to be, it's 15 years is the maximum, and we're saying that one for Kevin Rabbit was 14 years, 3 months. You're looking at the more serious end that tends to be fraudulent. A disqualification in the UK tends to be between 2 and 15 years. But one thing that I think is really interesting, right, and this is one that we've encountered recently. As a liquidator, you do a report to the Corporate Enforcement Office, or you do it to report to the DDU in Belfast, and you don't actually hear anything and it can drag on and then suddenly sort of 2 years down the line, or possibly even 3 years down the line, you hear something to say that they're going to take proceedings or not. We had cause to we handled a liquidation in over in London, and we submitted the report to the Directors Disqualification Unit. Now, they in England and Wales, they use a decision engine algorithm. Okay, and this is genuinely so. We submitted the report, and I went to make a cup of tea, and when I came back to my desk, the decision had already been reached. No, none of this hanging on for sort of 2 years or 3 years or even 10 in that case that Gary mentioned. I almost choked on my tea. Actually, I was that shocked, but it was they effectively they sifted out that case, decided that the directors had no case to answer for. Now, I don't see it that we'll ever get to that stage in Ireland, or not in the next 10 years anyway, that in Ireland we'll have decisions made so swiftly, but it was the similar types of things in terms of the director's conduct, the factors for be it a preference or be it unlawful disposition or a transaction at undervalue, they are all there in those jurisdictions. But I just thought it was an interesting one that the decision is sort of computer driven in England and Wales, while in Ireland we have to wait for quite some time. Anything else, Gary, or Damien? Any other questions?
Question around so from that case study, when a debtor does accept responsibility or liability for a debt, if that's unaffordable, is there any options for them to address it? Personally?
No, absolutely. I mean, quite often the liquidator will work with the director and will sort of maybe come up with some sort of repayment plan. Now, the liquidator will be expecting the director to provide details of their statement of affairs, so their own assets and liabilities, and trying to determine from a creditor perspective what's the best course of action to enter into that the director repays be it the unfair prejudice or the director's loan account or whatever it is, that they repay it over a period of time. However, if they can't repay it, you might enter into a repayment plan, but it may be that the director has other liabilities. In that case, I mentioned where they had incurred 600,000 of PGs. If the liquidator in that case had determined that there was a director's loan account of 100,000, then they have to get in line with everybody else in trying to recover that. So in those situations, the director would be looking at perhaps a PIA, but more likely a DSA, debt settlement arrangement, which is one of the statutory insolvencies that we have. And from a liquidator's point of view, it's kind of neat and it's tidy that it's wrapped up. That it's the best outcome that the creditors could hope for, and it gives you a degree of certainty that there's going to be a recovery over this X period of time. So although the director, their livelihood may be impacted, they get some time to sort of get themselves back on their feet a little bit, and then address that liability into the liquidation in some way. So a DSA or a PAA maybe, if there's if you need to sort of reject the mortgage, is definitely an option. But short of those statutory options, like I say, it may be that if it's really the only big liability that the director has, the liquidator would typically work with them in some way. And as I say, they can justify that and explain to creditors, listen, we're doing this because that's the best possible outcome, and it's better than bankruptcy. So
yeah, perfect. Thank you.
Anything you want to add, Gary?
No, just on the previous question there, the differences, like you covered that off well, but one of the things come to mind is in Northern Ireland, UK, it's look back period 3 years, whilst in Ireland it's 12 months.
Quite right. Yeah.
So,
but in both jurisdictions, it's any office holder. So
yeah.
We've had cases where somebody's come to us and said, they've been appointed a liquidator somebody who's sort of got signed off at CRO 11 months prior to the liquidation. They're still captured in terms of their conduct is still investigated. Their conduct is still looked at. Go to the next slide up, Gary. I think it's just the contact details. But oh dear, I maybe wouldn't have said that had I realised there was that photo. But that's my contact details. And Gary, I think yours are on the next one.
So
yeah, Gary,
we'll just leave it yours.
Much better photo of you than one of me. So, guys, that's actually, we're coming up spot on time. If anyone has any questions that occurs to them subsequent to this, please do reach out to myself or to Gary. I hope you have found this informative and useful. We've been running a series of these, and we've had some sort of a good level of attendees with some really, really sort of tricky technical questions. So I'm very pleased that you could take the time. Hopefully we didn't disturb your lunch too much, but thank you very much for joining us, and we look forward to the next one.
Yeah, no, just second that as well. And look, also, like we've at times we'd be thinking about topics for these webinars. So look, if there's anything that anyone particularly would like covered, please feel free to reach out to us and let us know. We can certainly incorporate it into the next one or two.
Great, guys. Thank you very much. And as Ronan and Gary were both saying, feel free to reach out. I'll maybe send an email afterwards, and any questions or anything you want to follow up on, feel free, and we'll get back to you as soon as possible. So enjoy the rest of your day, and until next time, take care and thank you very much.
Okay, bye now.